Yesterday, was the big day for the Supreme Court because the issue was the constitutionality of the individual mandate itself. And as you know, the individual mandate is the portion of the law that says you have to carry health insurance, and if you don't, you pay a penalty. So the constitutional question with the mandate is whether or not that is a legitimate exercise of Congress's power to regulate interstate commerce. And, you know, there's two very good sides of that argument. On one side, the argument is, well, you're not in commerce yet necessarily because you haven't bought or you're choosing not to buy health insurance. But you're going to inevitably be in the stream of commerce because healthcare is unique. Everybody uses it at some point in time. So the government's argument was, well, we're just sort of regulating the timing of when that commerce power kicks in.
So it's not like car insurance.
It's not like car insurance. Yeah, and in fact, it's not like car insurance for a very fundamental reason. The sovereign or the governmental entity that requires you to buy car insurance is the state. And the state has, under the legal regime we have in this country, what's called residual power or police power. And police power is much, much broader than what the federal government has the power to do. The federal government is what's called a government of limited and enumerated powers only. If you pick up the Constitution, you look in Article 1, Section 8, there are literally 18 what's called power sources. And if Congress wants to pass a law, a federal law, it has to justify the law as based in one of those 18 power sources. When it comes to the individual mandate, Congress has to prove that it is grounded in the power to regulate interstate commerce. States don't have that legal burden. Because states have this residual police power under the 10th Amendment, they can do many things in a legal sense that the federal government simply cannot do. So when it comes to the individual mandate imposed by the federal government, we have to figure out if this is commerce or not. When the people who are challenging the law came up for oral arguments, their argument was, you're not yet in interstate commerce. As someone who is opting not to buy health insurance, you're sort of the antithesis of commerce. You've chosen not to engage in any commercial activity, and until you do, Congress doesn't have the power to regulate you. The key to the constitutionality of the individual mandate is that, and it all comes down, to most court watchers' opinion, to Justice Kennedy, who is sort of the conceptual swing vote on the court right now. And I will say that I had very mixed feelings about what Justice Kennedy said in oral arguments yesterday. At the beginning, I think Justice Kennedy was saying things that were encouraging for the challengers, because one of the first things out of his mouth was, doesn't this law fundamentally change the relationship between individuals and the federal government? And that suggests that he's concerned about expanding the scope of the commerce power to not regulate commerce, but to compel it. And he's also concerned about changing the structure of government and the relationship between the federal government and the state government, something lawyers generally refer to as federalism. And those are two things he's sort of well known for. He's well known jurisprudentially for concerns about federalism, and he's well known for concerns about individual liberty.
So that point of view boiled down would be like, if today, insurance, tomorrow can they mandate broccoli? I think that was what I was
right. The broccoli hypothetical.
Right.
Yeah.
Or something else. Is that what that commerce?
Absolutely, because one of the things that all members of the court were struggling to figure out yesterday is whether, if they uphold this individual mandate, they could identify any sort of limiting principle to the commerce power after that. Because if Congress has the power to force you to buy health insurance because your failure to buy health insurance affects everybody else by cost shifting, then presumably Congress has the power to force you to buy virtually anything. Think about it: if you don't pay your mortgage, if you don't pay for your food, if you don't pay for your shoes, if you don't pay for your clothing, that's not a free moment. That's a moment where your decision, essentially to be a deadbeat on some level, is shifting costs to everyone in society. The people who are selling those goods and services have to either raise the prices directly, or the consequences societally will be felt by things like laying people off of work or cutting back their hours or something like that. So there's really sort of no free lunch, if you will. And so if this mandate is upheld, the court's going to have a hard time figuring out where the commerce power stops. And if they can't figure out a way where the commerce power stops, we don't have a government of limited and enumerated powers anymore. So yesterday's oral arguments left me with the impression that Justice Kennedy, who is known for his sort of strident positions as a defender of individual liberty and a defender of federalism, is likely to vote against the individual mandate. And if that's the case, I don't see any of the four other sort of conservative justices trading places and going to the other side. So I think he is the key fifth vote. And I do think that we have a 5-4 decision invalidating the individual mandate. There's going to be a lot of hue and cry as a result of that. People are going to take the position that it's judicial activism. In my view, it's actually judicial engagement. A judge does not act improperly when he enforces the parameters of the Constitution. So I think it's sort of very unfortunate that people politicize the Constitution the way they have. This is not a court decision about the policy wisdom of the health care reform law. It literally is a very serious non-policy question about the meaning of the Constitution. So once they make their decision, and they'll probably make their decision, frankly, Friday morning. Friday morning, just a day after arguments end, at 10 o'clock in the morning, the justices will sit around a very large table in a conference. And nobody will be allowed in the room except the 9 of them. They don't allow their secretaries in. They don't allow their law clerks in. Nobody can enter the room. And they will they will go in order of seniority and talk about what their impressions are based on the oral arguments. Once they've gone around the table in order of seniority, the Chief Justice, John Roberts, will know at that point who is for invalidating and who is for upholding. And he'll count heads, and he'll know where the majority lies, and then he will assign one of his colleagues in the majority to write the majority opinion. If he, Justice Roberts, is in the majority, he has really sort of two choices. He can take the bull by the horns and write the opinion himself, or he can hand it over to someone like Justice Kennedy, who is viewed to be the swing vote in this case. And my guess is he'll do that. If Kennedy is voting to invalidate, Kennedy will write the majority opinion in this case. And then whoever's on the other side of the view will write dissents as they wish. And we will have a decision by the Supreme Court by the end of June.